Welcome to Truth Be Found. Join us as we slip through the shadows and into the world of high-profile investigations with our host, professional investigator Justin Yentes, as he peels back the layers of the most perplexing cases, unmasking secrets to uncover the truth.
All right, I want to welcome everyone to the show today, to Truth Be Found. We're really excited to have Mr. Mark Berardoni with us this afternoon. Mark is a distinguished criminal defense attorney, and after graduating from ASU and California Western School of Law, you began your career at the County Public Defender Service here in Maricopa County. Since 1992, Mark has been in private practice, representing clients both in state and federal courts. You've had some pretty notable successes. We'll call one of them the Dougie case, Arizona versus Dougie. And Mark is really known more than anything, at least in my view, for his significant trial experience and his ability to really connect with the jury and with his clients. He and I have collaborated on cases for the past 12 or 14 years or so.
It's been a long time, Justin. It's been a long
we had lunch before this, and we were trying to determine which was our first case together, and neither of us came up with a good answer. We've been to trial a couple times in the last 18 months, one on a homicide out of the Indian Reservation just east of here, and another on a multi-million-dollar fraud case involving the theft from the owner of a very large, notable cosmetics company. Anyways, he brings a lot of experience to the table, and we're glad to have you.
I'm really happy to be here. Thanks for having me. I'm excited, but also a little bit nervous. It's not really my cup of tea to do things like this.
No, you generally like to be the one asking the questions, don't you?
That's correct.
Okay.
Yeah, I know my forum, and this is not the forum I'm used to.
Right. Okay, well, we'll just pretend we're in a courtroom and you're on the stand, I guess.
Oh, is that okay? Good.
Which doesn't really happen very often. Now, Mark, if I remember correctly, you kind of cut your teeth in the wholesale restaurant and food services industry before going into criminal law, which is a bit of a shift. Can you explain kind of what drew you from the restaurant industry into criminal court?
Yeah, I sure can. What was really happening is I started off at the University of Miami after graduating high school. During that time, I was working in restaurants. So I sort of worked my way through restaurants and I started to learn how to cook at that point. I did that for many years, up until the point where I actually, through a family business, was running a restaurant. At that time, I already knew that I really wanted to go into law, but that's where the track was taking me. And then I came and decided it's time to go back on track, came out here, finished up at ASU. And at that time, to kept me through school, I decided to go into sales. And that's where I learned sales. The reason I'm even dwelling a little bit on those is because I honestly believe that because of what I learned working in restaurants, which was to identify with people, humanize people and stay with that, was helpful. But then, of course, through sales, that's where you come in and you learn how to be persuasive. And that's, I thought, was a huge thing. I didn't start law school till I was actually 30 years old.
Okay.
My goal was to actually graduate by 30, but I wound up going to law school at 30 and graduate by 33.
Okay. You know, and I one of our prior guests, you know Kurt Altman.
Yes, I do.
Yeah, so we were talking about that on his episode, that at the end of the day we're somewhat in a sales position, because we're trying to bring a jury or a judge or a prosecutor or sometimes even a defendant over to our way of thinking. Would you agree with that, or?
Well, since Kurt became a defense lawyer, I agree with him a lot more. But I know him obviously when he was a prosecutor, and he was fine. He was a fair man at that point. He's 100% correct, and that's exactly what I tell people. I'm going to switch the word sales a little bit, because it's the art of persuasion, if you will. Yeah, we are. Not only are we trying to persuade judges, juries, probation officers, the prosecutors themselves, but our clients as well, and sometimes the family members themselves. And that's really what it is all about. It's not truly sales. It's not your high-pressure salesperson. It's how can you get someone to come into your point of view. When people ask me, yeah, if they want me to mentor them and help them with the art of persuasion, the first thing I tell them to do is to go get a book, and it's called Getting to Yes. And that book is basically put out by the Harvard negotiation team, I believe it was. Very short book. But I learned a lot of little things from that book, and that's exactly what you must do, is to try to get people, not to trick them, not to connive them, but to see your point of view and make them understand your point of view while identifying their point of view and getting to yes.
Okay, I like it. Well, how is it that, so you started out in the public defender's office here in Maricopa County, and that must have been somewhat of a baptism by fire. I know that nationwide, our public defense offices are generally pretty overloaded. And I know in that office, you had a string of trials, and you seem to be in trial more than anyone else.
Well, I will
Talk
also.
to me about that.
That is true. And just to give you another point I went through, when I became a public defender, as you pointed with the county, we were fortunate enough because there was a case, I think it was called State v. Lewis. And what that was is that the public defenders were overly, they just had so many people that they were overwhelmed. And then that case came in and says, you have to cut the amount. So I had the benefit of already coming in at that point. When I came in also, there was a new leader, Dean Trebish was running the show at that time. And I think I was fortunate enough to come in on that new fringe. But as you point out, yeah, I did do more than the average bear over there.
Yeah, you did.
Yeah, and myself and another colleague he's at the federal public defenders, Jeff Williams, right?
Yes, one of the twins.
One of the twins.
Funny thing, I always thought he was just the hardest working attorney that I'd ever seen, but
Because you see him.
because I saw him twice as much.
Well, had you worked with him, you would see it's the cheeks. You could always tell by the cheeks. Gerald has the high cheeks, Jeff does not. So, and now Gerald's retired, so it's even easier.
One less.
Right. So the reason why Jeff and I had more cases than the others is because we actually were asking the others who didn't want to go to trial. We would take their cases. And so normally in the 2 years that I was there, I probably would have had 5 or 6 trials on my own. But because I was taking other people's cases in the 2 years that I was there, I wound up doing 13 different trials. And yeah, that's a lot of jury trials.
It is.
That is, and Jeff, I'm sure, had just as many. And both of us were quite successful, beating the national average, if I may brag just a little bit.
Please do brag. I mean, I think it's notable to mention that you spent a lot of time developing that skill, as not only knowing the law and knowing how to argue it and apply it to various sets of facts, but also presenting that and those facts and the law to a group of laymen, a group of jurors.
Well, that's exactly right. And again, it's back to the persuasion part. And one of the things is you just reminded me of one of the cases that I had was Larry David Noble. And Larry David Noble had been in prison not once, not twice, but 3 times. In the last 12 years before I met him, he was in prison 10 of those. He was accused of stealing a car in South Phoenix. A lot of my cases were out of South Phoenix. And the reason he was driving the car is because Wanda had stolen this car, but didn't know how to drive it because it was a stick shift. And so she asked Larry David, would you mind driving the car for me? And Larry David did drive the car. And he got stopped by the police. It was a stolen car, and they arrested Larry David Noble for stealing that car. It was an interesting case. I won't go into all the facts. The point I want to share with you on this is, you talked about persuading a jury. I learned something there that I took with me through my whole career, and that was probably my 2nd or 3rd trial. Larry David Noble was basically offered almost time served back in those time periods. And if he went to trial, he was going to be facing over 10 years.
Ouch.
And I don't know if I can get a little bit colorful here, but I remember
of course.
I was nervous. Well, that's good.
I think we have an explicit rating on our
Do we? Are we
podcast
okay?
already, so feel free to say whatever.
Well, good, because I remember going to him, and I was a young lawyer, and I was like, he's looking at time served. If he goes to trial and loses, he's going to look over 10 years.
And so just for those that don't understand, what does that mean when you're talking to a defendant and they're looking at a time served resolution? What does that mean for those that don't have that background.
Okay, sure. Well, it boils down to this. A time served means that he's in custody at the time. If he resolves his case at the time of sentencing, he'll get credit for the time he served and he'll do no further jail.
Okay.
So time served is his sentence. All the time you served ends your sentence.
So, Mr. Noble, that's what you were looking at that point?
At that point.
Okay.
In retrospect, obviously the prosecutor saw some of the weaknesses in the case, but I got concerned. I'm a young lawyer and I've got this man's liberty. And if we lose this trial, he's going to look at 10 years. And that's because he had prior felonies in his mandatory sentencings at that point. And I just went to Mr. Noble and I said, Mr. Noble, are you sure this is, what you want to do? Do you understand the risk you're doing? He said, I don't care if they offer me time served. I'll still tell them to shove it up their ass.
Really?
Yes. And I'm like, we're going to trial. We are going to trial. I also brought in my supervisor just to make sure, because I was concerned that I was at least presenting this properly. But Mr. Noble obviously had been around the block. And so we did go to trial. And speaking of bragging, we'll get to what happened here. Yeah.
Right.
So during that trial, I went to a lot of seminars, and the public defender was wonderful about training you. And you had your mentors, and you had a lot of people that were very helpful. Paul Prado was my true mentor there, and I was preparing for the cross-examination, and that could be another whole podcast in itself.
Right.
But what I do remember is, when I went to the officer, we were trying to point out when he goes up and sees a stolen car, that a lot of times there's a lot of things. You'll see screwdrivers, for example, in the ignition. You will see other indications that the car has been stolen. And I remember going to the police officer and I said, now, when you went up there, you didn't see a steering wheel, you didn't see the wires coming out, and you didn't see broken glass everywhere. And so my voice, when I went there, I've used the word everywhere. When I spoke to the jury, at that point, the foreman comes up and he says, well, how could we have convicted your client when they didn't find glass everywhere? So that's what I learned, that the inflections and the auditory aspect is something that you have to put in to make sure that there's something that the jury hears. Again, am I tricking them? No, but that's part of the art of persuasion.
Okay. So you're looking through the facts of the case as we prepare for trial, and looking for what points that you need the jury to latch onto. Is it that they can't come to an understanding of every fact, and there's just too much information that you have to select what you need to focus on, or how is it that you make those determinations of what to drive home with the jury?
That's a pretty wide open question to me. I don't know how to hone down to where you're at, because several things go through my mind at that point, Justin. You know a couple of the things that I basically do. When I'm looking at a case, if we're going to trial, for example, the first place I start, and maybe my colleagues don't always agree with me, is I start with what is my closing argument going to be. And by the way, people listening, please don't say closing statements. That's always a pet peeve, all these people doing that. It's closing arguments, opening statements. And people don't like to be with me because I do criticize on those.
You do.
I do. I certainly
okay.
do. So that's where I start, is how am I going to, what am I going to present at this closing argument? We have terms that we use in public speaking, is primacy and recency. Are you familiar with those terms? Primacy is you got to start with a bang, and recency is you got to end with a bang, and then you fit everything in between. But to hone down on basically what you were saying about the facts, I learned I had a very large trial. And matter of fact, the trial that you and I do, and I think we'll speak about that case, had just overwhelming amount of information to sift through and things. But I remember doing a trial, and I always, after I'm preparing for it, I would like to run it by somebody that's not a lawyer. And I was walking around the block, which is part of my process. It used to be Kiwanis Park, and now I just walk around the block a couple of times. And I go to see a neighbor, and I said, hey, do you mind if I tell you about this case? And I realized 20 minutes later, I was still describing the case. And I'm like, I have not synthesized all the evidence that I believe to be relevant in this case. So I had to learn a process to somehow synthesize it. And I came up, I see you smiling.
Oh yeah, I've heard it several times.
I think you could tell them.
Bingo, bango, bongo.
Bingo, bango, bongo. That's right. And what that really stands for is, of course, you can't simplify everything like that. But the bingo, bango, bongo is where I'm able to say, hey, this case is about bingo, bango, and bongo. And now I can explain the case. Of course, then I can go into each of those elements, try to, again, use persuasion to try to show them why my client is innocent. Now, I said innocent, but that's not really what the law is all about. They have to prove guilt beyond a reasonable doubt.
Correct.
So I don't have to prove innocence. But my daughter, who's very smart, when I would tell her about the case, she would go to me, she said, well, Daddy, you didn't tell me your client was innocent. Every case we do, every case you and I have gone to trial on, we are saying he's innocent, but in the same breath we go, however, we don't have to prove innocence. That's up to the government, blah, 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 and things like that. But so that's what you do. You have to synthesize the facts, put them in a logical way, and then try to make all the facts, even the bad ones, in their best light for the jurors or whoever you're trying to persuade, prosecutors, judges, et cetera.
Okay. And this is one thing that you and I have gone back and forth on over several of our cases, where I come at it from an investigator standpoint of providing facts and interviews and evidence that you can use, and it's your job to present those in the most favorable light to the defendant in the court. Would you agree on that aspect?
I do agree on that aspect. I'm going to supplement it and call a little bit of BS on you too.
Okay, I'll take it.
Okay. we usually sit and have a little chat. And then I usually write you an email saying, look, here's the areas I need you to look in. But the last area is always, and anywhere you think this investigation should go,
Right.
you go there, and things like that. So you are, anytime that I have a case, and I have you on it, and we've had many cases together
Right.
over the years, we actually work as a good partnership. And I got to tell you, you have partners with a lot. I know you work with a lot of defense lawyers, and you have a lot of good partners, and everybody loves you and respects you. Like I said, I heard Doug talking about you. Yeah, they do. You're great. But you're not just an investigator. You're so much more than that. One, you love the law, and you're constantly pushing cases. You're pushing legal theories my way. So yeah, so you're not just the investigator, and especially when we go to trial, you're my equal, and we're hashing this whole case out back and forth. I could not have gone, and I don't know if we should use the real name. So
You can use a pseudonym.
a pseudonym.
Yes.
Well, let's just say the fraud case that
Yes.
we had. Okay, and I couldn't have done that without you. And it's not just you investigating that case. We were there, shoulder to shoulder throughout. I mean, just hours and hours and hours. I mean, that's why I learned about Uber Eats.
Yeah.
I'm like, wow.
That was a brutal case. We started that case the Monday after Easter,
Right.
and I had, during an Easter morning Easter egg hunt with my kids, I had fallen over and smacked my head on the side of a bathtub.
Right.
Ended up with
Rocky Raccoon.
two black guys walking into the federal courthouse that morning.
People are all like, oh, what happened? It looked like you're in a fight. And oh, my goodness, and stuff like that.
I called you that morning, say, look, Mark, I don't want to make you nervous. I'm coming to trial, but
That's right.
But I do have two black eyes, and I apologize.
That's right. It was the whole trial was quite interesting. But you're right. That would have not only made me nervous, I would have been, I don't know what I would have done because you were there. Like I said, you're not just an investigator. You're a team player, and you're fantastic on that. You do the legal aspects, and we can run and do ideas off of each other and stuff like that. So.
Now, how is that of benefit to you as a trial attorney, to have a non-attorney challenging your arguments and bringing you different non-attorney ways of looking at your case?
Attorneys sometimes are myopic. They always think ABC, we always think objectively, we think in legal terms. That's what law school does to you. It trains you a certain way, and your mindset just gets those pistons running a different way. When I walk down a street, I don't necessarily see telephone lines or cars. I see, oh my goodness, look at that car, he's too close to the curb. Oh my goodness, look at those wires, they can fall. There's always an analytical part that we're trained with. We stay myopic. So having a person like you run it by, that adds a full flavor to everything at that point. It keeps me from being just myopic and things like that. And that's what you would do. You would say, that there is no way that's going to fly. And so and it worked out really well. That case we were just talking about, there's always something you learn. I've been doing this over 30 years. The thing about that, there was a lot of things about that case besides your black eyes, was the overwhelming amount of stuff we had to go through.
Right.
All those emails. And it wasn't just people just writing emails. Then it was who was copied on the email. And then you had to go through that whole set of emails again. You're saying, oh, I recognize that, I recognize that, I recognize this.
And what was the attachment on each email?
And well, that did become an issue.
It did become an issue.
That did become an issue. That'll be another podcast.
That will, because we can dissect that case.
Forever.
And talk about the strengths and weaknesses of knowing what the content of your email attachments based on that one try.
That's exactly right. And that, by the way, that case is on appeal. And so I heard that the prosecutor left, but I'm going to make sure he comes back in case we get number two on that.
We'll take another crack at it.
Yes, we will.
Justin and Mark versus the FBI. So you've had also some pretty amazing successes, and I believe we're referring to this case as the Dougie case.
The Dougie case.
Could you walk me through the Dougie case and why you feel like this is one of the examples of your work over your career? Best prime examples, I should say.
Yeah, the thing about the Dougie case, most of what we do, 90+% of what we do, first of all, we don't go to trial. 90% of it is negotiating some type of deal with the prosecution at that point. So we only go to trial on some of them, and we've talked a little bit about trials. This was a case, and I do believe that of all the cases I've done, I've had great negotiations, we've had great victories, but this is one that I think I really impacted a young man's life, and I'm very proud of that.
Okay.
This gentleman he had just graduated a local high school, and he and his friends went over to their friend's house where the parents were out of town, and it was a typical party, a graduation party. Everybody had consumed alcohol. There were so many different ins and outs of this thing. I can probably speak for hours on this case, but the gist of it, or why it stands out in my mind, is this young man was introduced to a girl. He was 18, she was 16 and a half, and they were supposed to meet. Mutual friends set them up. And she was intoxicated. He was intoxicated. And these kids always have a video. And that always becomes a factor when they have the video. But the long essence of this is she woke up the next morning, this young lady, and she got concerned. I won't go into all the details. Leave it to say she got concerned about something going on with her. And so she went to her aunt and told her aunt, she says, I don't know exactly what happened last night. And so her aunt says, and her uncle was a Mesa police officer.
Now, are we talking about did she suspect that she had been assaulted or?
No, I guess I should probably explain. What was happening was she did have some blood coming from her vaginal area.
Okay.
And she knew it wasn't, it wasn't her menstrual cycle at that point. That's what got her concerned, I guess, to give context to that. And anyway, the Mesa police officer gets so upset because her parents were out of town camping. And so then they take her to the hospital for a sex assault to check. And at that point, they meet a detective from one of the local municipalities. And this guy just starts talking to her about, well, you didn't do anything wrong. You were drunk. You were the victim and things like that. She's afraid she's going to get in trouble because she's at a party. And now all of a sudden, she's now a victim at this case. And I have nothing to say. She was very fine, this young lady, throughout this whole thing. the point of this story is he was charged with 5 sexual accounts. This is an 18-year-old boy with no prior history of anything. And he was now facing 31 years mandatory minimum in prison.
Wow.
And he would have to register as a sex offender if he went down on these counts at that point. And the story, she never said that he did anything to her without consent at that point. But the thing is, and there's 2 parts that bothered me on this case is, the laws, what happens is laws are created because some people think that people are getting away with something. So Arizona has a law that says if you are intoxicated, you cannot use that as a defense to what you're doing. So he's charged with a sex assault. But the fact that he was drunk and couldn't tell that she couldn't consent was not a defense for him. So that was one of the laws that we had to deal with there. The other one is those mandatory sentencings at that point. And so her position was, look, I don't remember anything. What did you ever say? No, I never said don't do it or don't do anything like that. And he kept saying, she never said no. And her behavior was consistent with her having a good time, if you will, at that point. We could not convince the prosecutor of that. And so there was really no offer on the table that was acceptable. And this young man went to trial, knowing that if he was found guilty, he would have been in prison till he was 31 and registered as a sex offender.
31 years from then, right?
Well, he would have been 31 when he got out.
Oh, okay.
31 when he got out. They were 5.5. Each count was 5.5
Okay.
years.
Okay.
So, and we didn't even win it the first time. There was a co-defendant in the first one. That young man was found guilty, and he went away. He only had 1 mandatory count, no prior history, and he went away. And then we had to retry the case the second time. And fortunately, that time we did get a not guilty. A big help on that was a friend of mine, Becky. She helped me look at how the detective was interviewing her, talking about having a non-lawyer. She helped me identify some of the jurors that we wouldn't want or would want on the panel.
Okay.
So that one's important to me because I was fighting mandatory sentencing, I was fighting silly laws, and I was fighting a prosecutor that I don't think had world experience.
Now, how you mentioned the laws that you didn't agree with. That was in addition to the mandatory minimums. What were the laws that you didn't agree with?
The fact that what he was charged with was that he should have known that she was intoxicated and could not consent. That was what the sex assault was. So, and the fact that he was drunk, and he was extremely drunk. Everybody was. These are kids having their day with alcohol, things like that. So that was the other law that bothered me, that I could not raise as a defense that he was so intoxicated. He couldn't see that she was so intoxicated and couldn't consent.
Okay.
And never once was there any of that. And that's what the law really was, is she's so intoxicated that she couldn't consent and he should have known it.
Okay.
And so that bothered me a little bit. It's not your traditional classic rape, we have no, or those types of things like that. This is more of if anything, a grayer area, but I saw him as completely innocent in this case.
Okay. Now, has the law changed since that point, or is the law the same from the time that Dougie went to trial to now?
I believe I don't do as much state work these days. I do a lot more federal work, but I don't think anything significant has changed in the law there. Certainly not the mandatory minimums.
Right.
And I don't believe that they've changed the fact on what we call a specific intent crime, where you have to have a specific intent to do something, can be taken away by drinking voluntarily alcohol.
And that's one of the areas that I feel folks sometimes don't have an understanding of, is the types of cases that we are confronted with don't always have a clear black and white, yes, no, guilty, not guilty. There's very often a shade of confusion or a shade of gray in between the two that we have to sort through and parse out and come to a resolution on.
That's correct. And when I taught at a law school for a couple of years, that the students always wanted that black or white. And that's when I would always have my buzz phrase basically saying, that's why you go to jury. They're the ones determine whether it should be black or white, And as you're saying, it's really a grave factual situation.
Okay.
So it's up to the jury at that point.
It is, and it's a scary position to be in. I should say that you and I are not the ones that end up having to serve the time if our client goes to gets found guilty. But it's a scary situation for everyone involved to put the future of your client in the hands of 12 unknown people.
And as I tell clients, I can go to trial in your case 10 times, but I don't expect to win all 10. I wouldn't expect to lose all 10, and that's the variable.
Right.
Because each juror comes with them with their own packages. But in that regard, I will say one thing. What I have seen, when you do have a jury, they're always very dedicated. I've never walked away saying, oh, they weren't doing their job. And the collective consciousness of them, I think, is impressive. It is impressive, things like that. I could share one little quick funny side note.
Please do.
I will certainly will. And in that same case, we were talking about the Doogie case, I stopped going to see what the jury says at the end. But in this case, because it was such a big case for me, I did go back to the jury just to see if there was some insight, sort of like I got from that gentleman that said we didn't find glass everywhere. That was the first time I had to use my reading glasses. And so, because I was at that point where I just was like, I had to make sure I can read it. And I went in and talked to this jury pool. And the only question they asked me was, we were trying to figure out if you really needed the glasses or was it just a prop?
And that's what they took out of it.
That was the big question in this trial of my career. Did you really need those glasses?
Wow.
And they said, well, because you were cleaning them with your tie and you're like twirling them, putting them in your mouth. It's the first time I ever had the glasses in a trial. So I guess I didn't know what to do.
That you do fidget with them during trial. I think
with everything during trial.
I might have grabbed your glasses during our last homicide trial because I got tired of listening to the chewing on. When there's a reason why folks say, don't make a federal case out of it.
Right.
Phil Hantel used to say that to me.
Right.
And the reason is that usually when a federal case gets to indictment and someone's arrested and charged, they've got a pretty solid case behind them. You don't generally see the feds throwing mud against the wall and taking cases to trial or charging them that they don't think that they can win.
Oh, first of all, that's an ethical thing that people don't realize. The difference between a prosecutor and a defense lawyer is we have to do our best for our client. There's certain different jargons that's changed over the years ethically. But a prosecutor must, first of all, do justice first and foremost. And I know Doug had a few people that he didn't think
We're doing that.
We're doing
Right.
that. But the thing is that they also have to have a reasonable likelihood of conviction, which again is a standard or bar term. So that's why you'll see that they may not take the cases to trial or even file them if they think that they don't have a reasonable likelihood of having success.
Because I can recall one of our cases that we had early on. We'll call him Mr. Raven.
Okay.
And he was charged with taking, there was someone that was in the mail system, in the postal system, that was finding government checks and passing them out to him, and he would take them and deposit them into his personal little small business account.
Right.
And no one noticed when it was $1,000 or $2,000, a couple of tax refunds here and there went missing. But then a government grant check to the tune of well over $250,000 was sent out to a foreign entity, and that one got intercepted. Right. And so when you saw that one dropped into the bank account of it was a cleaning company, right. Obviously, just like on Dumb and Dumber, when they're holding up the IOUs, you're going to want to hold on to that one. That's $250,000.
Right.
And so when $250,000 went missing,
right.
Eyebrows were raised, and that led directly to our client. And there were 52, I believe, checks that had been taken from the Treasury, varying amounts, totaling well over $300,000-$400,000. And his signature was on all of them, and
right.
the videos of him depositing was on all of them.
Right.
and then we get handed this to resolve.
Right.
And I say it was difficult. I had just hired a fairly new investigator, April,
Right.
and she went and charmed the pants off of him. And I think he got starry-eyed with her,
Right.
and was very forthcoming with us. But the facts were so problematic.
True.
And how is it that you take a case like that and come to a resolution? Because not all at not all points are defendants in agreement with the facts.
That part's true. That part is true. Sometimes you do have the client that's willing to be completely honest with you. You have the ones that won't be completely honest with you. Some won't say anything to you with regards to it, which is on one level okay, because really, as we say, you don't have to prove innocence. We have to just see how the government's case is going to come out and look at what they would have to prove and see how the facts or the evidence matches up to that. Of course, it is nice to have the rest of the story. And that certainly reminds me of our homicide case, the frustration we had with regards to some of that case, without going into too many details. But it really boils down to it. And I remember the gentleman you're talking about. What a nice, stately gentleman. Oh, very pleasant. And most of them are pleasant to us. I won't say all, but most of them are very pleasant to us. And I remember a judge once saying, criminal law, the difference between a criminal law client and a family law client is family law is good people at their worst, and criminal law is usually bad people at their best.
Right.
And so I always remembered that. But to answer your question, because I don't want you to say non-responsive, I get that enough.
Okay.
So, most of what we do is negotiate, like I said. So that was a nice gentleman. I don't believe he had too much of a criminal history in him. So there's good in that case. It's an overall case. This isn't a case that most likely you go to trial unless the client is insistent. And those are the ones that do go to trial. If the government's case is relatively weak, or there's a mandatory sentencing and his offer is only a difference of a couple of years, why not roll the dice and go through the whole thing? But that one did settle. And because it's just negotiations, you have to weigh how strong is the government's case. That bodes against this. But is there mitigation on this gentleman's case? And he was an elderly gentleman. He ran a business, and that's what it is. It's a negotiation, and we try to, again, get to yes. We try to get to where the government is satisfied with the resolution, as is the defendant.
I know you mentioned that the homicide case that we just took to trial. This was about, was what, 18 months ago?
Right.
And we'll call the guy Nick.
Yeah, let's call him Nick.
Nick, it's a good name.
That's good.
So Nick, if you remember correctly, was charged with committing a homicide in a small trailer out on an Indian reservation, just
I do remember
east
that.
of Scottsdale. You probably remember because we went out to search for the missing murder weapon
Yeah.
and were attacked by
2 dogs.
some pretty savage pit bulls.
Yes.
One that may or
You
may
were, not me.
I was. Well, and that's only because you can run faster. So
Yeah, I do remember that.
I ended up with in a bush with my foot trying to push a pit bull off of my leg.
Right.
And I don't know, you were probably on the other side of the bush.
We were right next to each other, actually.
Oh, I figured you were there taking pictures.
No, I wasn't taking pictures. I was taking pictures of the scene, but not you in the bush.
Okay. being mauled by the rabid pit bull.
They were scary.
But at the end of that trial, this was a trial that went on for a week or two, and we had a lot of questions. The murder weapon had never been obtained.
Right.
There hadn't been a lot of forensics done on the scene. There hadn't been a lot of trajectory done. There were some pictures that were taken on the scene by the local PD, and the FBI, I believe, responded, but not as thorough of an investigation that
Justin, it was probably one of the worst homicide investigations I ever did, and it was fortunate for us. But you're right. We went out to that scene regularly. We had spatter we had to deal with. We had ballistics that we had to deal with, trajectories, like you say. I even during the trial, I was being handed a police report in the middle of the trial. I remember holding it up in my hand, going, This is a homicide trial. You're giving me this today?
Yeah, during trial.
Remember that?
Yeah, oh yeah, I do. It
remember-
wasn't the first time it happened. I got handed DNA results on the morning of jury selection,
Right.
showing my guy's DNA under the nails of a suspect.
Right.
No, at the end of the trial, and we, our defendant had a lot of face tattoos. There were some arguments between him and one of the witnesses,
Yes, I
some
remember.
yelling back and forth from the table. But the homicide he was actually found not guilty of.
Well, it was the lesser included.
With the lesser included, exactly. And so could you explain to our listeners how that works? How someone could be charged with one thing and then be found guilty of something much less significant?
Yeah, absolutely. He was originally charged with first-degree homicide. He was also charged with an aggravated assault and then using a gun in relation to that aggravated assault. I don't want to go, this would be something for a class to
Right.
teach about how those all fit together. But just to answer your question, let's just, for simplification, if you will, not for you, I know you understand all these things. You were sitting right next to me. But the homicide is first degree. Now, the government may be concerned that the jurors may not have agreed the way these facts panned out, that it was first degree, which does require some intent and some thought, some deliberation, very small amount, but some deliberation. The advantage for the government is if he went down on the first degree homicide, first degree murder, he'd be in life for the rest of his life without a possibility of parole. Now, the government then decided well, maybe we can give the jury a choice. And that would be, we can do a lesser included crime of the first degree homicide or murder. Let's go second degree. The elements aren't as hard to prove for the government at that point. And so once they decided to do that, I wanted to try to get our little, well, if you're going to have first and second, let's give them something else to think about.
Right.
And so we chose all the way down the scale, which is involuntary manslaughter, which had a maximum sentence of 7 years, where the second degree, for example, would have been life, but with the possibility of parole or a minimum of 25 years to be more specific. And so that's basically what we did do. We gave that jury an opportunity to decide not just on first, second, but also on involuntary manslaughter.
Right.
And that's the way they came in.
That is the way they came in. This is a perfect example of shoot for the moon, you get the stars.
Exactly. I do remember when I said to the judge, we want the lesser included involuntary man. There are some rules that say you have to have facts that justify getting that jury
Right.
instruction. I remember saying, well, please be patient. I will lay them out for you. And sure enough, we laid them out, and that's what we got.
And it was a great result, and I want to congratulate you again for that.
Yeah, well, I want to congratulate you because, again, but you weren't just the investigator. You're sitting right next to me. We're running that whole case. We're listening to those tapes of, remember all the body cameras?
Oh, yeah. Oh,
my
yeah.
goodness.
Yeah, that was
I think every officer in that, the police force was at that scene.
they were all there, and they all had recordings going, and they all had cameras going.
They did.
And the dog is still what haunts me.
That's funny. That's what I do remember that.
Oh yeah, yeah.
And to go full circle, by the way, Jeff Williams, the gentleman that was a public defender with me, he's now a federal defender. He had this case first.
Oh, okay.
He found out the results, and he's like, "What?"
He was probably thrilled. I'm sure he was. Well, Mark, I really want to thank you for coming on today. It's been a pleasure working with you. You've been a friend and mentor of mine for a long time, and we'd love to have you back and talk about some current cases going on, and just want to say thank you for sharing your experience with our guests.
Well, my pleasure, and thank you, Justin. I'll come back anytime.
All right, thank you so much.
Thanks for tuning in to Truth Be Found. Keep the pursuit alive and subscribe to the realm of high-profile investigations as each secret edges us closer to the truth. Until next time, stay vigilant.